Okay, just one moment and we'll get started.
Thank you, Mr. Lilly. I think Mr. Terry from our office, who's probably assisting Mr. Moore, is trying to connect here. I see on the window.
Yes, I see that. I was going to wait for him. I hope his connection is okay.
Yeah, me too.
It says connect on my screen. It says connecting to audio. Oh, there's a check mark. That's a good sign. He's in. Okay, good.
And then I don't see Mr. Moore. Oh, there he is. Okay.
I see a window with labeled Tim Terry, but it looks like Mr. Moore is actually in the screen. So
yeah. And just for your information, Mr. Terry is a paralegal who's been assisting us on this case.
Okay, I'm certainly glad to have him join us today. Okay, I think I'm going to go ahead and get started. It looks like we have everybody who's trying to get in. First of all, I apologize for the delay. It just took me a minute to get everything hooked up at my end, so my bad. But let's go ahead and get started. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. Today is Wednesday, October 19, and 2022, and it's just after 9 a.m. And this is a pre-hearing conference in the court's reference to the State Water Resources Control Board, which has been assigned to the Administrative Hearings Office in this case of City of Marina versus RMC Lonestar. With me today from my staff are Skylar Anderson, Kyle Woldridge, Amy Blunk, and Nicole Mullen. And we also have two new members of our team we're very happy to have on board, Regina Graziano and Natalie Stork from the State Water Board's Office of Research Planning and Performance. And they are both engineering geologists. James Nachbar, the head of that office, has volunteered for them to provide us technical support to me and my team in this proceeding. So very happy to have them on board. Some of you may know Ms. Stork appeared as a witness for the prosecution team in another proceeding before my office involving Blue Triton brands. And I have cleared with the State Water Resources Control Board's general counsel that consistent with the California Supreme Court's decision in the Morongo, I think it's called Morongo Band of Indians or Morongo Tribe decision. She can participate with part of the hearing team in this matter. And of course, we have made it very clear we will not discuss anything. I will not discuss with her. Nobody on my team will discuss with her anything involving the Blue Triton brands proceeding. So that's how we plan to proceed with that. The other preliminary announcement I wanted to make is that I have announced or advised the State Water Board members in closed session that I plan to retire at the end of the year. And they have actually advertised, and some of you may have seen it, for the vacancy announcement for my successor. I do plan to stay on in a part-time role, and the board has authorized this as necessary going into next year to complete the pending proceedings that I have, including this proceeding. So even though you'll see that announcement and may wonder what's going on, it will not affect my work in this proceeding, which I will continue as necessary. So with that, I think I don't see any court reporter here. We, of course, are recording this by Zoom electronic recording. And of course, the parties have to have a choice to have a court reporter, but it doesn't appear that anybody's asked for that. So I think I will go ahead and just ask for appearances, and we'll go from there. So first of all, for CalAm, who is appearing today for California American Water Company? If you can,
Rob, you're on mute.
Yeah, go off mute and then talk.
Rob Donlin for Cal American Water.
I'll try again. Bob Moore, Alan Matkins for California American Water.
David Osias, also of Alan Matkins for CalAm.
And Catherine Dorning with California American Water.
Okay. So good morning to all of you. For Marina Coast Water District, who is appearing?
Jim, you're on mute.
Good morning, Kyle Brochard, Richards, Watson, and Gershon for Marina Coast Water District. Also on the line is Jim Markman for Marina Coast Water District.
Now I'm unmuted. Sorry.
Howard Wilkins from Marina Coast Water District.
Ruth Stoner Muzine, also from Marina Coast Water District. Good morning, Your Honor.
All right, and good morning to
Christina
all of
Berglund,
you. Oh,
representing.
I'm sorry, Ms. Berglund, I didn't mean to interrupt. Excuse me.
That's okay. Good morning, Christina Berglund with Remy Moose Manually, representing MCWD.
Great, excuse me. Okay, and for City of Marina, who's here today?
Good morning, Mr. Lilly, Skip Spalding, for plaintiff, City of Marina.
And good morning, Mr. Lilly. Larissa Meisenheimer, also on behalf of the City of Marina.
All right. And good morning to both of you. And then for RMC Lonestar Cemex.
Good morning, James Neudecker for RMC Pacific Materials.
Okay, I'm sorry, I guess the name changed. That's the official name now, RMC Pacific Materials.
Yeah, and CMEX is a DBA.
DBA.
And everybody calls it CMEX or CEMEX, including me. So CMEX it is.
Well, we'll try to get it right when we are to the point of preparing our draft report of referee. But thank you all and good morning. Okay, I think that covers everybody I see on my screen. Have I missed anybody? Okay, well, thank you all for participating this morning, and I appreciate receiving the pre-hearing conference statements last week. Very helpful for kind of my preparing for my agenda for today. A couple of preliminary questions. One is just out of curiosity, my staff and I are wondering, everybody filed their slides on October 5th, even though my last order had specified September 28 as a deadline for that. And I was just wondering, did you all reach some kind of internal agreement to extend that deadline by a week? Because we haven't seen any paper on that, and we were just curious.
Yes, Your Honor. The parties had all met and conferred on a number of issues. One of them was the summary slides. We all needed a little more time, and we all knew you were on vacation and didn't want to bother you and your staff.
Well, I know from my days of practicing as an attorney, I was always hesitant to tell people when I was going on vacation because I was afraid they'd take advantage of me. But in this case, it's fine. I'm not planning to go on any more long vacations while this proceeding is pending, except for the big one after it's over. But if you do that in the future, if you could just send the AHO an email with copies to everyone on the service list, it would be good for us to know. I mean, it was fine in this case, but I just say I'm a little curious that apparently there was an agreement to extend the deadline and nobody told us about it. But that in this case, it's fine. I've now downloaded all the slides and we're ready to go. So thank you for that clarification. The other question preliminary I had is, I know you were planning to take some depositions, and I'll just start with you, Mr. Brochard, since you volunteered before. Can you just tell me which depositions have occurred?
Tim Durbin has been deposed, and the Marina Coast General Manager, Mr. Scherzinger, has been deposed. Mr. Leffler is scheduled to be deposed tomorrow, and Mr. Ye is scheduled to be deposed on Friday.
Okay, so October 20 and 21. Okay, and that's it so far for depots?
That's it so far. Mr. Ash's deposition was on calendar, and CalAm informed us yesterday that they were canceling and taking that one off. So Mr. Ash is not going to be deposed.
Okay. Okay, and I'm sorry, but I'm trying to remember. I believe with the staggered filing deadlines for expert testimony, I assume there potentially could be depositions of the additional witnesses who will be submitting their written proposed rebuttal testimony later. Is that correct?
That is my understanding, Your Honor.
Yeah, okay, thank you. Okay, so that's good. So let me just go down the things I have on my list to talk about today. It'll just be efficient to get as many of these things resolved today. So when we start the hearing next Wednesday, we won't have to spend time on this. So first of all, there's a question of time limits for oral opening statements, and I have received all of your written opening briefs, which I appreciate. That's quite helpful for me and my staff to just sort of see where you're all headed in this matter. But I did provide for oral opening statements, and then of course summaries of the witnesses' direct testimony using their summary slides, and cross-examination. I've read the parties' statements in their pre-hearing conference statements on this issue. Is there anything else anyone would like to add on that before we go forward?
Not for Cal-Am, Mr. Lilly.
Okay. Okay, how about for Marina Coast? Anything further?
Our position is in the joint statement, Your Honor. Just I did notice that Cal-Am submitted a second statement saying that the time limit shouldn't be changed. And I would just like to note that the plan all along has been to decide the time limits today in the court's June 1st order. It specifically noted the issues that were going to be talked about at the second pre-hearing conference, and that's time limits. So that's why we addressed it, and we've addressed it in our other pre-hearing statements also.
Okay, well, thank you. And I do agree with that. I think I looked at the initial notice, and it had some times, but of course that was before I'd seen any of the written testimony or summary slides. So that was why I sort of left that open for further consideration. So I will look that over and discuss that with my staff, and then we'll issue an order. I'll issue an order stating what I think are the target times for those. Again, I want to give everyone an opportunity to be heard, but having said that, there's obviously a lot of written material that's already been submitted, and we've read most of it, and we're working through all the details, and we'll reread it. And that's the advantage of written documents over oral, is we can go over them again and again as necessary. So having said that, I think the oral times can be somewhat shorter. But on the other hand, I do know you want to have chances to speak, so I will consider that. I think and I don't know if anyone wants to speak up for Marina Coast or City of Marina on this. I think your joint statement asked for basically splitting your opening statement time, since your witnesses are going to be some testifying in the first part of this proceeding and then some in December. Is that correct? Is that still what Marina Coast and City of Marina want to do?
Yes, Your Honor, that was the proposal. It would be hard to give an opening statement about what our experts' responses are going to be to their new model before we've had a chance to complete evaluating it and actually prepare their testimonies.
Well, I don't think anyone can dispute that, so that's fine. Okay, so as far as opening statements go, somebody also asked in their pre-hearing conference statement whether PowerPoint presentations would be okay. And the answer is yes, although, please, I think you should be able to keep them to a maximum of 5 to 10 slides. It will be easier if you just have a separate file for the opening statement rather than asking us to refer to slides, some of your witnesses' slides. I mean, if you want to copy them into your opening statement, that's fine. But if we just have one file for each opening statement, then we can just click through it, and it'll save us the time of having to pull up different files and go forward. And I ask that you file those with the AHO on or before next Monday. Wait, let me make sure I've got the right date. Here. Today's the 19th, the 24th at 1 p.m. And you can upload them to your AHO upload file. Those PowerPoint or PDF files tend to have a lot of megabytes, so it's probably better to do that than to email them. But then just send us an email with copies to everyone on the service list advising us that you've done that. And just so you know, we have about 30 upload folders from in that folder on the board's FTP site. And we don't check them to be impractical for us to check all of them several times a day. We have them for lots of different proceedings. So that's why it's important for you to send us an email advising us that you have uploaded them. And to further add complexity, we have upload folders for some law firms and then also for some parties. So tell us what, and it's okay, but just tell us what folder you've uploaded it to so we can download those and transfer them over to the public FTP folder. So, but that's fine. Any questions on that? And with that, we'll have them ready to screen share, and then whoever's giving the opening statement can just ask the next slide.
Yeah, Mr.
I
Lee,
have one quick.
Go ahead, Mr. Moore.
Okay. If it's going to be 20 minutes, it's 20 minutes. We don't have a big objection to that. What I do have an objection to is splitting it up. Effectively, that gives them two rebuttals. Their first opening statement will have, after we make the opening statement. The second their opening statement then is made before the next phase, after they've heard everything. If it's going to be, and I think this happens in California state courts all the time, you can save your opening statement after the other party put on their opening, but you can't break it up. Because I think that is an unfair advantage to them to say, oh, we'll take 10 minutes now and 10 minutes later. I think they can choose either one. It's not up to us to decide, but I think breaking it up is not fair.
Okay, and the answer is I'm going to allow them to break it up because they're going to be having some witnesses testify in the first phase and some witnesses testifying in the second phase. But your point is a valid point. I expect that let's call it the first half of their opening statements to discuss what their witnesses who are going to testify in the first round of hearings are going to testify about. And then in the second opening statement will be what those witnesses are going to testify about. I mean, as I see it, the purpose of an opening statement is really to just provide a little bit of roadmap and information on what the witnesses are going to testify to. So that's why we'll do it that way. And frankly, Mr. Moore, your point does have some validity. And I think what we'll do is we'll have CalAm go first. They'll give their opening statement about all their witnesses. And then when Marina Coast goes forward, they can have an opening statement limited to their witnesses. I think that will make it a little easier rather than they're giving an opening statement before CalAm starts putting on its case. I don't know. Does anybody from Marina Coast or City of Marina have any objection to going forward that way?
No, Your Honor.
Okay.
No objection.
Okay.
To follow up on that, it sounds like the order will be CalAm first, and then I think we had anticipated CEMEX second, then MCWD, then the city. Is that still the order you're anticipating?
Yeah, I sort of started and then got distracted, but I plan to have CalAm go first. Mr. Newdecker, I don't think CEMEX submitted any witnesses, did they?
We didn't submit any witnesses, but we do plan to cross-examine at least one, and I will have something to say in openings. It will be short, but I'll have something to say.
Okay, and would you rather give that before or after CalAm puts on its case? I'm inclined to have it be after, just sort of the way we're doing things here.
So the question is after CalAm puts on its case or after CalAm?
All its witnesses, yeah.
I need to refresh my recollection and maybe the city can remind me, is Lane Long scheduled to testify in the first session?
Yeah, but I'm talking about CalAm. So CalAm would put on its whole case. Then you'd give your opening statement without any witnesses. Then Marina Coast would give its opening, and then City Marina would.
That's fine. Yes, after CalAm's case is fine. Thank you.
Okay, and I will.
To clarify, Mr. Lilly, just to clarify, are you envisioning the opening statements would all go sort of that first morning? You know, everyone would give an opening, CalAm, CEMEX, MCW. Are you envisioning opening statements would proceed when people are putting their witnesses on?
I had planned what I said, maybe I wasn't clear, was that each party would give its opening statement right before it presented its witnesses. Now, but I realize there's some, on the other hand, you may want to give your opening statement earlier so that I have some idea where you're headed during your cross-examination. I don't know. Do you have a feeling one way or the other about that?
Then
I'll start. Go ahead.
Skip, do you want to take the first swing?
Or
I'm
Mr. Spalding.
actually fine doing it either way.
Okay.
Yeah.
All right. Well, so here's what I plan to do. And I will write this all out. So don't, if you miss something, I'll try to have it all confirmed in writing. But I think the order of the parties, my plan for the order of parties is Cal-Am will go first, CEMEX will go second, Marina Coast will go third, City of Marina will go fourth. And for each party, each of those four parties, the order will be opening statement by that party's attorney, one of them, and then that party will put on its witnesses for summaries of direct testimony. And the way we normally do it in these technical proceedings is they'll put on the summaries of all of their witnesses, and then we'll do cross-examination. Just because otherwise, with four witnesses, we'd have to do 4 rounds of cross-examination. I'll just ask. And let me finish what I was going to say, and then I'll ask. And then the same thing with CEMEX. For CEMEX, it's just an opening statement. And then for Marina Coast, its opening statement, and then its witnesses. I think it has 2 witnesses that are scheduled to testify in this round of hearing. And then cross-examine or opening statement, summaries of direct testimony for Marina Coast, 2 witnesses, cross-examination of those witnesses. And then, of course, I forgot to mention also questions by me. And then City Marina would do the same thing. Opening statement, summary of direct testimony. I think it only has 1 witness for this phase. And then cross-ex and questions by me. So does anybody have any comments or concerns about that process?
I have a question, and that is, are we summarizing direct and rebuttal together or just direct?
Okay. Another good question. And the answer is summarize the testimony that's going to be given during this phase of the hearing. As I think Mr. Rochard said a few minutes ago, you can't really summarize your rebuttal witness's testimony when you haven't prepared it and submitted it yet. So, it doesn't really do me much good to have sort of an advanced summary before I've seen that written proposed rebuttal testimony anyway. So is that clear, Mr. Spalding? I hope I was clear.
Mr. Lilly, I think our question is that several witnesses, like Mr. Ash, has short rebuttal testimony. Obviously, Cal-Am has rebuttal testimony for their witnesses. And the question is, you said a summary of direct testimony, then cross. And our question is, does the direct and rebuttal testimony get summarized together, followed by cross, or are you envisioning direct and then cross and then rebuttal and then cross? We're trying to understand that.
That's right. I assume, Mr. Spalding, that's what you were trying to say, and it didn't sink in, so I apologize.
Yeah.
So it's really for Cal-Am's witnesses that you're asking the question, because they're the only ones that this is going to, well, no, that's not true. Your witness, some of them have submitted rebuttal as well. So the answer is, what I'd like the parties to do is have their opening statements summarize their witnesses' direct and rebuttal testimony that has already been submitted. And then the witnesses will provide their summaries using their summary slides of their direct and rebuttal testimony that has been submitted. And then cross-examination of that panel of witnesses, that party's panel of witnesses, will proceed on all of the testimony that those witnesses have submitted. And then my questions, obviously the same way. So basically we'll go through, for each witness, there will be 1 summary of direct, 1 round of cross-ex, 1 round of questions by me. I guess there potentially could then be some redirect, but I think that's going to be the most efficient, because the rebuttal and the direct testimony, there may have been some overlap, and I don't really want to go through 2 whole rounds for each witness with that. So number one, is that clear? And number two, does anybody have any comments on that?
Mr. Lilly, I that's clear. I don't have any comments on that other than you said panel in the middle of that. And I was curious if you're envisioning all the experts on for CalAm or are parties and one expert this time around being presented together and sitting on a panel, so to speak. Is that how you envision this going? Well, all witnesses will be there the same day.
That is my plan. And that's the way I know that's not the way you normally do things in court. But the reason that's the way the water board normally does it. And the reason is that with this technical testimony from these witnesses, there sometimes is overlap, often is overlap between the witness's testimony. And witness A may say, well, I can give a short answer to that, but witness B, sitting right here to my right, is much more qualified to provide detail on that. And then we can just go right to witness B and we don't have to go round and round and round. So that was the water board's practice before my office was even created. And I've carried that practice forward. So that's what I plan to do. No one way is perfect, but that seems to be the most efficient to me to go forward that way. So I'll ask again, does anybody have any follow-up? Does anybody have any questions or comments about that?
And so the time limits that you're referring to, you're going to be setting, in essence, time limits to cross-examine the whole panel. So if we have 2 hours, it would be to ask, for us to ask all questions we have of all CalAm witnesses during that time.
That is correct. Yeah, since it's a panel, there's really no way I can split it up, or don't need to. So that's my plan. Okay, any other questions or comments about that?
Yes, Mr. Lilly. I think our biggest question is we envisioned when we set those time limits, they would be for each witness as opposed to a panel of witnesses. And, the way this is currently scheduled, we have 2 days of hearings here for everyone. It sounds like maybe even one day to get it all done. And we have a lot of time blocked out, obviously, for this on our schedules. So it would be helpful, and maybe you're getting there, what days you're planning to actually hold hearings and figure this out.
Yeah. Just
okay.
To piggyback on what Mr. Wilkins just said, I think when we put in our time estimates, it was, 2 hours cross, but it was per witness. If it's just 2 hours cross for all of the witnesses for one party, I think we have 14 days of hearings blocked off for testimony. You could probably do that in 3 days if you're limited to just a couple hours.
Okay, well, so I've blocked off October 26, 27, 28, and 31, and November 1, 2, and 3. So that's a total of 7 days, and then planning to do the site visit on November 4th. So I agree, 2 hours per panel, particularly for cross-ex of CalAm's witnesses, since there are 4 of them, may be too short. But I certainly hope we can finish this all in those 7 days. That's my plan. And I will think about what is an appropriate amount of time for cross-ex. I'm sorry to have to put time limits at all on that, but I just do. I've just, in my experience, otherwise it has a way of just droning on and on and on. And it doesn't often lead to a lot of productive information transfer. So that's my concern, but let me give that some thought and think about what, and I do have the written proposed testimony and rebuttal. So that gives me some idea of what the scope is of the direct and rebuttal that people may want to cross-examine on. Let me ask one question on this, though. Since you've taken or are going to take depositions of most of at least of CalAm's technical witnesses, Durbin, Leffler, and Ye, that should allow you to really focus your cross-examination. If we've got the direct and the written and the rebuttal, and of course I can read that and put that up on the screen. So it's pretty clear what the witnesses are going to testify to. And then there may be certain points you want to bring out on cross-examination, but hopefully you can do that fairly quickly. If you have their deposition transcripts of their depositions, you know what they're probably going to say on cross-ex. So if somebody can comment on why they think 2 hours per witness for cross-ex is necessary, I would appreciate that.
Well, I guess, Mr. Wilkins, I can take a stab, Mr. Lilly.
Go ahead.
We haven't taken what I would consider CalAm's witness who's covering the most topics. Mr. Leffler is scheduled to be deposed tomorrow. He's talking on a broad range of issues on both direct and rebuttal, and talking about multiple models, and also taking on the testimony of our experts, including on AEM, which hopefully you know what that term is now. And
I do.
The other testimony we've provided. So it's difficult to know how much time we're going to need from Mr. Leffler, but I will tell you, similar to some of our experts, like Ms. Nelson, who's testifying in a large number of the 8 issues that you were asked to give your opinion on, that is going to take time to go through all of those 8 issues. And there's a lot of background, and I realize that it's in testimony or what our opinions are and what CalAm's opinions are, but for even us to guess on what some of the responses are going to be from Mr. Leffler and Ye are difficult because we haven't taken their deposition yet. But I do anticipate it will take some time to set the foundation to even ask some of the ultimate questions. And there's a lot of graphics you may have noticed that CalAm has submitted, that our experts have submitted, and to explain those, your technical staff, and you may know a lot more than I do, but I need some time to understand those myself when my experts put them up. It just takes time to go through these very large testimonies and make sure that you understand the nuances, because there are a lot of nuances here. And so we're trying to make sure you get the best information so you can evaluate the credibility of the evidence and the experts' opinions. And I just think that will be impossible to do within 2 hours. I also don't think it's going to take more than 7 days. I don't think it's going to take 6 days. But
okay, don't forget that 7 days includes the Marina Coast witnesses, 2 witnesses, and City of Marina's 1 witness. So it's not just CalAm.
Right. I don't think I think our rebuttal, our experts who are going in phase 2 will take more than a day. I think CalAm will want more than a day with them. And
I think I've scheduled about 5 or 6 days for that. So
and you have, and we're talking for 2 witnesses, and so I don't think it'll take. I think 2 days is probably the right amount. Maybe it's 3 days, but I'm looking at, if we only have 2 hours for the entire panel for all of CalAm's 4 people, that's a 1-day hearing for all of CalAm's witnesses. That's the way I'm trying to understand how we're going to fill up even 3 days if this panel suggestion is what is going to go forward, and I don't have any objection to that. But I don't understand where the time's going to come if they have really short summaries and we have really short crosses. I guess maybe you're going to question them for a couple of days, and that's okay. I'm just trying to understand.
No, I assume that was facetious, but
no,
we don't know enough yet to cross-examine for a couple of days. We're learning.
I'm just trying to understand how this is going to work.
I would echo what Chip said. I think there is an incredible breadth of information here. We've got 8 different topics, and it is really detailed and really complicated. And often you have to ask a number of questions to set the stage to get to the point you're trying to make. There also has been a lot of background information that's been introduced, and it looks like it's going to be put in through CalAm's fact witness that I think the parties have differing perspectives on that will have to be addressed. But in an even bigger sense, just taking a step back, we're, 2-3 years into this pandemic, we're all getting used to being remote. But the one thing I have noticed is that when you're trying to cross-examine someone on a remote platform, it just takes longer. It takes longer to get the document up. It takes longer for everyone to get to the document. There's always some inevitable kerfuffle or something that doesn't quite go up right. It takes time to direct the person and manipulate, to the right page, and then for everyone to get there. So I do think remote cross-examination just takes a little bit longer.
Okay, well, that's valid. And my staff is really, really good. I'll just tell you at pulling up exhibits. I frankly don't know how they do it as well as they do. But having said that, when there are large files, and there certainly are large files, it takes a while for them to upload sometimes. No matter how good somebody is at clicking, sometimes the computer is the limiting factor. And of course, we're all working remotely, so there are questions with getting it on different computers and so forth. So these are valid comments. But on the other hand, my comments are valid too. And I'll just say a couple of things. Number one, a lot of times you can make a better point through your own witnesses on rebuttal rather than through trying to get a witness on cross-examination to admit something that he or she is never going to admit. I'll just say that. I've done this for a while too. So keep that in mind. And another point is, don't necessarily think you have to make every single point on cross-ex. I mean, certainly there are some critical points. And, if you think the witness needs to admit something or clarify something that's not clear in his or her written proposed testimony, I understand that's what cross-ex is for. But just I'll just say be selective in what you think you need to try to cover on cross-ex and can cover on cross-ex. I mean, where in my experience, where it can really bog down is when a lawyer just keeps trying and trying and trying to get a witness to admit something, and the witness, he or she, is just not ever going to admit it. I mean, at some point, that's just not very productive. You're all experienced attorneys, so you know that. So keep that in mind. But I will give this some consideration, and I do agree. I mean, Mr. Leffler and Mr. Ye's testimony and their memoranda are long and detailed, and certainly I understand it's going to take more than 2 hours to get through cross-examination of those. So we'll keep that in mind. I'm going to say, let me just say one more thing before we shift over to you, Mr. Moore. My normal rule is that only one attorney per party conducts the cross-examination of a witness. Now, it's a little tricky here because we have panels, but I would like, and I don't know what you've all, this is, for all three parties. Well, Mr. Neudecker, you're by yourself, so it doesn't apply to you. But for the other three parties, I would like you to have one designated attorney to do the cross-ex of the panel of witnesses that you're cross-examining. Is that, I'm going to ask for answers to that, and then I'll get to you, Mr. Moore. Does anybody have any problem with that?
I'll take a shot real quick. It's hard to say a full opinion on that before we finish our depositions or take the depositions of Mr. Leffler and Mr. Ye. But our cross-examination of the CalAm witnesses is going to cover a lot of this case is going to involve modeling, and it's going to involve multiple models created over a long period of time. There are different kinds of models. We're not all experts, or any of us, I imagine, on this screen are experts in modeling or hydrogeology. I mean, if you say only one person can do it, then only one person can do it, but it will be, I don't know that it would be as efficient because there's going to be a lot of breaks in conferring with colleagues to try and figure out if we're asking questions the right way.
Okay. Well, and I understand. And this is complicated. There's no doubt about it. And we're all lawyers, and we have some experience and expertise in groundwater, but certainly not like the technical experts. At least I don't. So it may be, I say, one lawyer per witness, but if it's a panel of several witnesses, different lawyers can question different witnesses. And I mean, that's a little in conflict with what I said before about the cross-ex may shift from one witness to another. But I don't want one party to have one lawyer ask a whole bunch of cross-ex of the entire panel and then another lawyer for the same party to ask a lot more cross-ex. And I do think that's, at least from my experience, that's normally what judges do as well. So I don't think I'm just making this that one.
No, I think that makes sense. If this was a normal court appearance and if we had one witness, we would likely have different attorneys cross-examining the different witnesses. And I'm sure we can set up a situation where that's the goal. And if it's a panel, someone else may answer the question. That just may be how it is. But I guess my hope would be that we have multiple attorneys with each attorney kind of specifically geared up to ask questions of a specific witness, regardless of who ends up answering those questions, and then kind of.
Okay, and certainly depending on who took the deposition, that may make sense. I understand. Okay, let's shift over.
I have one question, Mr. Lilly.
Go ahead, Mr. Markman. Mr. Moore, I haven't forgotten you. You raised your hand.
I'm still here. Yeah.
Go ahead,
sorry,
Mr. Markman.
I didn't mean to get in front of Bob, but here's the question. When we cross-examine this panel, the scope of cross-examination is not going to be limited to the summary statements, is it? It's going to also include the submitted written testimony and rebuttal?
Oh, absolutely.
Okay. I just wanted to make sure that we understood that.
Yeah, now there's, I probably shouldn't even say this, but I will. Government, and technically this is we're sort of an informal proceeding here. This is not a formal administrative hearing, but Government Code 11513, I think it's subdivision B, says cross-ex can even go beyond the scope of direct. I hope you won't need to do that, but certainly it's fair game to ask cross-ex on anything in the witness's written proposed direct testimony or written proposed rebuttal testimony. I mean, that covers so much. I'll say I would find it hard to believe you need to go beyond that, but you certainly can go to that whether or not it's in the slides.
Well, there are some very clever trial lawyers here. I've dealt with them for years, and it would be easy enough to have omit a soft spot in somebody's testimony in their summary, but have it sitting there and being a very important part of the argument. So that you answered my question. So
yeah. I mean, I've said it before. I'll say it again. This is not a game. Right. This is trying to get to the truth and the bottom line here. It's not sort of I gotcha, and now that the gun is fired, the game's over. It's not the way it works. So please keep that in mind. But Mr. Markman, your comment jogged something that's really important for me, and I've had hearings where presided over with a few of you before, but not very many. But I'll tell you what I find works most efficient, and this is back from my days when I was a lawyer representing parties as well before the Water Board. I think cross-ex of technical witnesses where they've submitted their written proposed testimony, written proposed rebuttal in advance is most effective if you ask us to put up the page of the direct or rebuttal you want to ask a question about. So it'd be good if you have a list, and we're very nimble. We'll get it up there pretty quick, have exhibit numbers, page numbers, and line numbers, and just ask me and my staff to scroll to that. We'll have it on the screen for everybody, including the lawyer and the witness to see, and then ask your question. It just really saves time. And then the witness knows what you're talking about, what you claim he or she said, and you can go from there. So please, almost without exception, I think cross-ex questions are best if they're structured that way. I don't know if I've said that before, but really, you have to do a little bit of advanced work, but you're going to have to anyway. But just try to follow that format as much as you can. I mean, maybe not for a preliminary matter or something in general, but for anything specific, I think it's going to work best if you go that way. So any questions on that?
It sounds like for cross-examination, examination of witnesses, if there's particular passages we want to put up while the person's doing a summary or cross-examining, is that going to run through your team? So we should be letting you know what we want on the board, or are we going to be doing the screen sharing?
No, at least so far, we found it works best for us to control the screen. Okay. So that's, and that's why exhibit, and we know it for the record anyway, obviously. exhibit number, page number, line number. And all the testimony has line numbers, which is very helpful. So, and you wouldn't believe how fast my staff can get exhibits up when you say that. They're very good. And they'll shift around. We'll certainly have the witnesses' written, proposed, direct, and rebuttal testimony ready to go. I usually ask whoever staff is handling that to load it onto her computer ahead of time so it goes faster. But then if you have exhibits, Mr. X, you testified about CalAm Exhibit 47. Could we put Exhibit CalAm 47 on the board? And I have a couple of questions about that. So, but as I say, normally, if you direct your questions to their written proposed testimony, direct or rebuttal, that will make it a lot clearer and quicker. And I mean, I think you'll get a clearer answer too. So it's in your interest to do that as well. Okay, so Mr. Moore, you've been, Mr. Wilkins, I'm going to shift over to Mr. Moore. He's been patiently waiting. He raised his hand about 5 minutes ago, and then I'll shift back to you, Mr. Wilkins. Go ahead, Mr. Moore. I think you had a question or point about something else. Go ahead.
Yeah, I might. To clarify what we're doing right now is one attorney asking the questions. That I hope doesn't limit another attorney sitting right next to that attorney when it comes, say, to technical issues or legal issues that they know more about. Because I was hoping to have that, and one person asking a question, but somebody kind of consulting in a cross-examination. So the person asking a question doesn't have to be a water lawyer, can be somebody entirely different, a trial lawyer. So I think that falls within your limitation.
Not exactly. I had sort of planned for each party, one attorney per witness for cross-examination. And again, maybe I haven't done as many complex cases in courts with real judges before, but I think that's normally the rule, that they don't have two or more attorneys. I mean, I know it's discretionary with the judge. There's no formal rule on this, but normally to keep it moving forward, I think judges, in my experience, have tried to limit that. So I'm not going to say it's a hard, fast rule, Mr. Moore. And if there's some specific question where you say, hey, my colleague has a specific question, and I just have him or her ask the witness that question. I'm not going to say, no, you may not do that. But what I want to avoid is having one attorney for a party go through a whole round of cross-ex, and then another attorney for that same party go through a cross-ex of the same witness.
Yeah, my proposal was that another attorney sitting here to help in understanding the questions being asked and the answers. That attorney's not going to ask any questions. He's just consulting with the attorney that's asking the questions to make sure if there's something comes up that the attorney sitting there doesn't understand, you have somebody else here to help. And I think that's pretty common. You have a lead attorney.
That's, in other words, you'd say, you want to confer, may I have a moment to confer with my colleague
sitting right here, right? Yes.
Yeah. I'm not sure what sitting right here means in a virtual
that's
world.
right. I guess not, but I'm pounding something over here.
Yeah. I mean, you probably have ways to send electronic messages back and forth off this record, but yeah, that's fine.
Okay.
I'm not, if you need to pause for that, that's fine. I mean, again, we're trying to get to the bottom line here. So if that process helps that's fine.
Yeah. Okay, good. Other comment I have is on the time for cross-examination. With the panel, I do agree probably 2 hours is not enough. This is not going to take days. We have 8 questions to answer. We're trying to focus on what the Superior Court wanted. I don't see this taking a great deal of time. It's going to take more than 2 hours, maybe 4 or 6 hours, but I think it could be done in a day. I mean, everything that's been submitted to you so far is going to be part of the cross-examination, because that's what the case is all about. And if they want us, one side or the other wants to spend a long time going through what's before you right now, that's what will take a long time. If they don't, and they focus on the questions, they ask the right questions, they already know what the questions are going to be, and they probably know what the answers are going to be. I don't think it's going to take a long time. I do concede 2 hours is too short, probably. I'm not even sure about that, but I do know that we can get it done within 4 or 6 hours.
Okay. Well, I don't want to debate this in the abstract, and I'll just say, Mr. Moore, you may have a different view when we get to the second round of hearing and you're doing the cross-ex of the other party's technical witness. I know how this works.
Well, but see, there's a record here. If I say that next time around, I assume someone will comment about my inconsistencies. So.
Somebody will remember. With this group, I am sure of that.
Right.
So anyway, we'll play it by ear. What I normally do, which makes sense here, is at some point I may say, okay, I would like an offer of proof from when we're in cross-ex phase from the attorney. You know, what are the additional subjects you want to cover? How long do you want to take for that? So it's not just going on and on and on. So let's play it by ear. Again, I mean, you can see I'm grappling here. There's a tension between wanting to be efficient and get this done in a reasonable amount of time, but making sure everybody has an opportunity to bring out legitimate questions. But I'll just say it one more time, and well, for now, I won't say it again. Really think about what you want to try to accomplish through cross-ex, because in my experience, and particularly for something this complicated, rebuttal often is going to be a better way. You know, then your own witness can say, you know, I read that witness's testimony and I disagree and here on these points and here's why. Boom, boom, boom. And you know, then of course my qualified staff and I have to confer to see who we agree with or disagree with. Usually it's somewhere in between, but that's going to probably be more productive than what you can extract out of a witness on cross-examination. I'll just say that from my experience. Okay, Mr. Osias, we haven't heard from you yet today. Go ahead.
Oh, thank you. I have more logistical sort of questions and process a little bit. They're simple, I hope.
Okay, well, I haven't gone through my script yet, so I don't know whether I'll answer them or not, but go ahead if you want, or you can wait.
Well, let me stay on the timing question a little bit, because we have all the direct testimony in writing and all the rebuttal testimony in writing. And because it's, as you noted, and I know more about than because I'm not a trial lawyer, it's more of an informal adjudicatory proceeding. It would be efficient, although in court not allowed, to ask a leading question of your own witness. But we have their testimony and we'll get through it. So if we wanted to put up their testimony as part of the summary and said, you know, in a leading fashion, and it's your opinion that, and you can see it, right? I mean, that's clearly leading, but we shouldn't, I hope, bog down on wasting time on objection leading.
Yeah, I'm hoping that with the summary slides, it can be more along the lines of, you know, witness A, please summarize your testimony using these slides. And that's the only question you have to ask. But
okay, but that's
you're right.
Right. That would be a narrative, and somebody would object in court that the question calls for a narrative. But that's going to be helpful here, I think.
Yeah. We're going to allow narratives.
Okay.
And that's, again, I think that's going to be more efficient, more effective than a bunch of leading questions of your own witness. I'm not saying you may never do that. I mean, this is informal, but I think a narrative, that's why we have the slides. So normally that summary works fairly well, is you can just have the witness go through their slides and you don't have to ask any questions at all. I mean, you know, one or two to get them started. I will ask, have you taken the oath? Is this your testimony? And then are these summary slides what you're going to use to summarize? Please proceed. And that's it. That usually goes a lot effect. And you know, and it gets the points across.
Right. And then my second point, which is on that very topic, and again, just so we don't do any of this on the hearing days, you were pretty clear, I think, that the testimony is the testimony and the summary slides are not submitted into evidence. They're for purpose. They're aids to moving the hearing along. So they are, at least in Cal-Am's submissions, brief summaries of, as you know, extensive testimony. And so when the cross focuses only on the summary slides versus the actual testimony, I think, going to your point about how to do cross effectively, they should be referring to an exhibit offered into evidence, which is the rebuttal, any exhibits they rely on for their direct and rebuttal. And they can use the summary, but we're going to end up with a witness saying, well, that's a summary. There's a lot more detail. Can I put up my testimony? That's how I understood the summary, what the summaries were. Is that correct? I guess would be my leading question.
Yeah, well, you can ask any kind of question you want of me. And the answer is not really. So the summary is the summary, but the witness is under oath when he or she summarizes his summary slide. So that is direct testimony under oath.
The oral part.
It's all, the first thing the witness does is affirm that the written testimony is his or her testimony. So at that point, all of that has been effectively given under oath, as if they'd sat and read their 71 pages. So that's in the record under oath as testimony.
Okay.
But then the summary slides, if they orally testify to that, they've taken the oath. So that's also testimony under oath. So I consider that all to be testimony. And frankly, sometimes our proposed order, or in this case, our proposed report of referee, will cite to the summary slides and the witness's testimony about that. I think that is testimony that's given under oath that it's evidence, it's part of the record. So similarly, if a witness wants to cross-examine, if an attorney wants to cross-examine a witness on his or her summary slides, they may do that. But as you just said, the witness may say, well, that's my summary, and I go into that in more detail in my written proposed testimony, and hopefully the witness will know where to find that, and I need to refer to that to answer your question. So I think that may cover your concern, but also answer your question about what is evidence and what is not evidence.
Okay, so perhaps I'm misremembering, but I thought that you had expressly said that the slides were not evidence. And they were more along the lines of demonstrative exhibits, which is what gets used in a lot of cases to illustrate a point, but aren't the actual, documents admitted into evidence. But we'll.
I don't think I ever said that, but I might have. I don't remember. At my age, I don't remember everything.
Okay.
But anyway, no, that they are evidence under oath. The slides are exhibits, but they are authenticated by the witness testifying under oath. So at that point, they're normally then admitted into the record as when other evidence is admitted into the record as well. But, of course, subject to other evidentiary objections that may apply. But anyway, that's it. So what I did say was the slide should summarize the written testimony. I didn't want people going off into new topics in their slides that aren't in their written proposed testimony, direct or rebuttal. That may be what you're thinking about that I'd said, but that's fairly clear because that's not fair to the whole process if somebody then starts putting in summary slides that are whole new topics that haven't been covered.
Right. No, that wasn't what I was thinking of.
Okay.
But that part is also totally understandable, and I agree with it.
Okay, you've got me wondering what I said before, but anyway, I'm telling you now what my view is.
Right. Well, like in a lot of environmental cases, this will be adaptive management. And
to some extent, that's true.
We will move forward.
Okay. Well, let me go forward with my list. Oh, Mr. Wilkins, your real hand is up. Go ahead.
Real quick question, and I apologize if you covered this in one of your orders. For documents that we've received as discovery in the expert depositions we've taken of CalAm's experts, those are not part of any exhibits currently in front of the water board. And I can't recall how we would introduce those for our cross-examination. Did you cover that before? And I've never seen it. And again, I have read your orders. I just don't remember seeing anything about that topic.
I don't know that it's in there. That's impeachment exhibits, I think, which I have here on my list. So can you hold the thought for a couple of minutes and I'll get
Absolutely.
there?
Yes.
And if I don't, ask the question again. Okay, so let me just go through. I've talked about order of parties. Somebody asked for each party to tell us what order they plan to call their witnesses, which I think is a fair question. So I'm going to start. Can one of the Cal-Am attorneys tell me what order Cal-Am plans to call its witnesses?
I can answer that question, I think, and that is.
Go ahead.
We haven't talked about that yet. We haven't decided. I hate to be disappointing, but David, unless you remember something I don't, we've not decided who's going first and who's going second, et cetera.
All right, and I just want to make sure I understand your question. That's correct. Mr. Lilly is, I read what you commented on in someone's CMC statement, but I think it was maybe linked to not a panel cross-examination assumption. So the sequence we put people on, but they're all held for a joint cross, is probably less important, but not unimportant. And we'll be prepared to tell you what order we'll put them on.
Okay, that's true. I think it's more important if you're going to have separate cross-examination, because then the attorneys doing the cross-ex want to know how to prepare. So it's less important for a panel. So I'm going to just ask you to let us know at the beginning of the hearing, unless anybody from Marina Coast or City of Marina thinks they need to know the order of witnesses ahead of time, considering that we will do cross-ex as a panel. I'm not hearing anybody raise their hands about that. So we'll do it that way. That'll take care of that. And of course, the same for this round, City of Marina only has one witness. Marina Coast has two. So again, right at the beginning of their case, they can tell us what order they're going in. Okay, so opening statements, short PowerPoint presentations will be okay. Please upload them to the AHO on or before October 24 at 1 p.m. And even though those will not be evidentiary because they're essentially going to be things that the attorneys talk about, I still would like you to give them exhibit numbers. Just follow whatever your numbering sequence is for your exhibits, because that way our record has a record of what the documents are that you're talking about. So just, give them an exhibit number, and in the label, just say summary slides for somebody, Cal-Am's opening statement, MCWD's opening statement, and so forth. That just will identify them. And then when we're admitting exhibits into evidence, we'll make sure not to admit those. But do that. We'll post them so everybody has them. And I don't know if I said it before, but I would like to have it be one attorney per party for each opening statement. So we'll have those ready for screen sharing. And of course, other parties can look at them ahead of time. The daily schedule normally is going to be 9 to 5 each day, unless there's something comes up on my schedule or anyone else's. 15-minute breaks in the morning and afternoon at whatever appropriate times are, and a lunch break at least 12 to 1, potentially a little bit longer, depending on how things are going. I know I used to be in your position. Sometimes having a break doesn't mean you're going to have a longer lunch. It means you can have a little more time to prepare for the afternoon of hearing. So I may give a little bit more than 1 hour for those, depending on how things are going. As I said, we will have the hearing exhibits ready for screen sharing. The ones that have a lot of megabytes may take a little while to get up, but I think we can normally get them up. Admission of exhibits into evidence. The way I normally do this is at the end of each party's case, and you have to remember because sometimes I forget, but we wait until after direct summaries, summaries of direct testimony, cross-examination, my questions, any redirect. Basically, when all the questioning is done, then the party may offer its exhibits into evidence. And of course, any other party may object on any of the legal grounds for admission of into evidence. And then normally I'll make a ruling right at that time, unless I need to take something under submission. And then my staff tries to keep a record of what's been admitted into evidence. But we find it works better to just do it all at once rather than sort of as you go just so we have a clear record on what's been admitted into evidence. So that's my plan on that. Does anybody have any questions about that? You know, it does mean you can ask cross-ex questions of a witness about an exhibit before the exhibit's been admitted into evidence, but I don't think that's going to be a problem here.
Just a quick question.
Go ahead, Ms. Meisenheimer, please.
Thank you. We have our world of proposed exhibits with numbering. They're all set, they're all squared away. We're also going to have the documents from the depositions that were produced more recently that are for impeachment. How do we handle that? If your team is doing the screen sharing, are we supposed to be getting you things in advance? Is there a way to do that without showing them to the other side? How do you want us to handle that?
It was actually the next thing on my list, so thank you.
Oh, perfect.
Impeachment. Somebody else asked about that earlier as well. So here we are. I think Mr. Wilkins. But anyway, impeachment exhibits, whether they can be anything, of course, and including excerpts from deposition transcripts. And that is one thing that's a little tricky to do when we're all working virtually or whatever, we're working remotely by Zoom. We do have to have them somehow transmitted to our office so that we can then screen share them so that the attorney can then ask the witness the question about the exhibit. So I do like to have them numbered. I need to have them numbered so that the record is clear on what document is being asked about. I don't know, I assume somebody's going to probably have a court reporter for this, so that's particularly important. But even for our video recording, we want to have exhibit numbers. So what I would like people to do is, if they're going to cross-ex with impeachment exhibits, to send those to us ahead of time and to number them. Again, just keep going down your number sequence for exhibit numbers so they're all numbered, please. They have to have exhibit numbers. And then we'll have them ready for screen sharing. And then, of course, at the end, you can decide whether or not to offer those into evidence. The question that comes up is, how soon do you have to, or do you have us make them available for the other side and the other side's witness to look at? And I know there's some strategy here. You want to be able to confront a witness with an exhibit and not to give him or her time to talk to his or her attorney about that to formulate their answer. But on the other hand, they have to have time to read it to be able to answer your questions about it. So how does anyone have any suggestions? I think I will follow the procedure. You can either email it to the AHO address if it's not too many megabytes, or you can upload it to your folder and advise us, and we can then transfer it to the hearing record so it's available, and then we can screen share it. But I would prefer to just get them all in the record ahead of time and have them be accessible to everybody, at least several hours before the cross-ex of that witness starts. But to some extent, that may not work logistically. So I'll start with you, Ms. Meisenheimer. Your hand was up. Do you have any suggestions on the timing question?
Well, one possibility for the deposition exhibits themselves, we've been trying to sequentially number those. So we'll have one set of deposition exhibits. One option would be for us to transmit the deposition exhibits to you guys in advance, and then we could list it by deposition exhibit, and that might resolve the issue for depo exhibits. I think it still remains, what we do with things that are new and not used in depositions.
How many exhibits are we talking about? I mean, is this 10 or 100 or what?
I think we're 2 depositions in so far, and there's maybe 25 exhibits.
Okay.
So far, it's not a flood.
Okay. So here's that's good. And of course, everybody's seen those, and certainly the witnesses have seen them or will see them during the depositions. So here's what I think works well for those. I do think it's good to submit them ahead of time. I would like you to number them as, either Cal-Am exhibits, whatever number you're on, 105, 106, and so forth, or MCWDs, 87, 88, 89, but then put in parentheses what the depot exhibit number is also, so we sort of all know what we're doing. But I think I want to use our numbering system for the documents, but cross-reference your depot numbering system. And if you can upload those, and that's you, each of you, up from your party, upload them to your party's file, and then we'll put them over into the record where they're accessible by everybody. And then, of course, we can screen share them. So that will be most efficient. And is it reasonable to do all that by next Monday at 1 p.m. so we have a day to get them all into the record? I'm not hearing a no.
No, this is Mr. Wilkins. I'm going to guess the answer to that is no, because we're taking a deposition on Friday that's likely going to last, I assume, well, a good portion of the day. And I guess I'm struggling with a little bit. I don't know that we're going to need all these as impeachment exhibits because we don't really know what they're going to say on the panel. And for example, the deposition transcripts won't be available by Monday. And I don't know that you need the whole depot transcript or the video recording of it to be uploaded in advance, but we may need that as an impeachment exhibit. We may not. So I guess, I think you don't know what impeachment exhibits until the witness takes the stand sometimes. And so I guess I am struggling a little bit with, do you want us to just put all the depot exhibits up there? We can do that. That probably we could do by Monday, but a lot of them probably, I'm guessing, we would not end up needing, but I don't know that.
All right, Ms. Meisenheimer, what's your comment? I'm on that. I mean, I'm pretty flexible on this. You're both raising valid comments.
I think the simplest path here, given how close we are to the hearing, the depositions are still occurring, and I think people are still going to be working on their cross-examination outlines into sort of middle of next week, would be for us to give you a full set of the depositions and the exhibits. And then when we want something up on the screen, we would, say Depot Exhibit 7, page this, line this. And it may be that for anything that gets used by the end of that day, we need to submit a supplemental list that, moves it off of the depot list onto our lists. I mean, there may be some way to still use our numbering, but I do think it's fairly complicated to try to get all of the deposition exhibits filtered onto everybody else's lists by early next week.
Okay. So what I'm hearing from both the kind of composite of what both of you are saying is we should have them in our administrative record, but not label them as party exhibits until we find out whether or not we're going to actually use them. So, and that's fine with me. I hope I'm not losing something here. Okay, are you all still there? I just got something telling me I might need to log back on. Can you, Ms. Meisenheimer, can you hear me still?
I can hear you.
Okay, good. Yeah, I just got a prompt from my computer, but I don't think it was for this. So let's do this. If you can upload the deposition exhibits, I'm trying to think of how to do this. Is it best to have a folder for each deponent so we can keep track of them? Have you numbered them sequentially for all the depots? Okay. So somebody, I'm going to put it on you, Ms. Meisenheimer, since you started this, unless somebody else volunteers. If you can upload all those depot exhibits to your upload file, what we will do is we will open a separate folder within the hearing documents folder for the administrative record called deposition exhibits. And we will put all those in there with your depot deposition exhibit numbering. And then they will be accessible. We can screen share those on CrossX as necessary. And anytime we screen share an exhibit for CrossX, at that point, we will number that exhibit with the party name of the party conducting the cross-examination and the next number in that party's exhibit sequence. And then those will go into the record. The depot exhibit folder, we will not have be part of the administrative record. But that way they will be, the ones that are used will go and will be available to be admitted into evidence. And then at the end of that party's case, the cross-examining attorney can offer those exhibits into evidence, and the other parties can object, of course, and we'll rule. I think that will solve that problem. So I'm going to pause there. Let me come to the deposition transcripts and recordings next. But does that take care of exhibits that are used during depots?
I think of one, Mr. Lilly, I think of one possibility that during, even during cross-examination, but during the presentation, one side or the other thinks of a document, a letter, an exhibit, or something else that hasn't crept into the record yet that may really harm the testimony, be an answer to the testimony that would hurt, and would want to send that to you or use it, and it hasn't otherwise gotten to you yet. Would there be an opportunity to ask for a short recess and upload it to the administrative hearing officer and then use it
For impeachment, you mean?
Yes.
Yeah, we can do that too as necessary.
Okay.
Hopefully there won't be very many of those. It's time consuming, but
Yeah.
That has happened in prior hearings. So, it turns out, well, this witness wrote a letter 3 years ago.
Exactly.
I think is really relevant for cross-examination, and I want to ask the witness about that letter. So obviously we have to label it as an exhibit and have it available, and then you can ask them. So yes, that can be done. I hope there won't be a lot of that because it does take time. So, okay, so Ms. Meisenheimer.
Mr. Lilly, pardon me.
Wait. I'm going to ask you to do that all by Monday at 1 o'clock if you can. It's one person just uploading one set of deposition exhibits. So hopefully that's fairly straightforward. Is that going to work, do you think?
I think it should work. And we're just uploading this to our FTP site and then providing notice, right?
Upload it to your FTP folder, yes, and provide notice to the service list and us that you have done that, and then we'll transfer it over.
The only hiccup is if for some reason we haven't gotten the exhibits from the court reporter yet by that point for Friday's deposition, but we'll push them and do everything we can to meet that deadline.
And if you can't, then just advise in your notice email that I've uploaded all these, but they're going to be this other set of exhibits. They'll come in and get them in as soon as you can.
Yeah, I think that should work well.
Okay, so that'll take care of deposition exhibits. I've addressed Mr. Markman's question about other impeachment exhibits, which will, if they're short enough that you can email them to us, just email them to the AHO email address and we'll put them in the record and give them a number. And then they'll be available for cross-ex. If they're longer, you'll have to upload them and tell us that. I don't know what our megabyte limit is, and we can do it that way. But that hopefully there won't be too many of those just because it's slow, but I do want to give you the right to do that if you think that there is something that's really relevant to cross-ex. And frankly, if there is, I'd rather you have the document than ask the witness in the abstract without a document.
Yes, right.
So, okay, so we're getting there. I haven't gotten to deposition transcripts yet. I'm going to. Mr. Osias, I think your hand was up a minute ago. Go
Yes,
ahead.
thank you. And this was just on the impeachment exhibits. And I'm,
Okay.
again, want to walk through the mechanics because we're virtual. If we weren't virtual, the entire document could be handed to the witness. So not only just to read it, but to, try to remember it and et cetera. When it's being to be used for impeachment, if they put the page up, that's the impeaching piece, what's the procedure you'd like us to use to allow this witness on screen to become familiar with the entirety of the document before answering? Mechanically is all I'm asking.
Yeah, I'm familiar with this question. I remember this from my days of being a trial lawyer. You give somebody a 300-page article and you want to ask them a question about one paragraph on page 87. And of course, the other lawyer says, well, it's a 300-page document. They haven't had time to read it. And you say, well, I just want to ask them this one question. So it's a dilemma. And about all I can say, Mr. Osias, is we'll have to play that by ear. If you think you need to have the witness see the whole document, then we'll have to upload the whole document and at least make it available. If necessary, the witness may have to take a break to become familiar with it. Usually, in my experience, what happens is it's a long document and the attorney wants to ask questions about 1 or 2 paragraphs in that document. So it's fair for the witness to say, I want to make sure I know what the document is, but then to focus on specific pages. So I think we'll just have to do it that way. At that point, the whole document probably is in the record, but the questions then would be focusing on certain pages. I mean, I don't know how else to do that. Frankly, it's a little bit more of a challenge when we're going electronically, although the same basic issue comes up even if you're in court in person.
So, I mean, was mechanically, we would say something to you at that time about a pause for maybe the witness to, look at the document. I wasn't going to try to suggest that if it's a 300-page document, in order to answer a question, he has to read all 300 pages, but he does probably have to determine as quickly as possible whether the document contains a more detailed explanation than an extract that's excluded, because sometimes things are taken out of context.
Lawyers can do that. So yes. And if it's a 300-page document, if he wrote it, that's going to be different than if he's never seen it before, obviously. And there can be something in between.
But our mechanics is just to notify you, we need to do something, and then we'll have a discussion about it. Is that what you have in mind?
Yes.
Okay.
And again, that's why we have breaks. And I mean, that's the sort of thing, if we can upload it before a lunch break, and then the witness can spend some time getting familiar with the document. And I will ask the cross-examining attorney to tell us all, including the witness, what pages he or she plans to ask the witness about.
Okay.
So I think that's the best we can do on that. Again, I hope you're not all planning on offering treatises on cross-examination. But, on the other hand, this is technically complex, and we have to do what we have to do to get the information all out. So, okay. So as far as the deposition transcripts go, first of all, were all these depots, are they all have been and being video recorded as well as the court reporter transcript? I see a yes from Ms. Meisenheimer. Thank you. And what's the status of getting the transcripts? When will the transcripts be available?
Yeah, at least the ones that we've requested. I think we're getting a 2 or 3 day expedited transcript. And so it will take a few days, but we should have finals by the time we start the hearing.
Okay. So here's what I'm sorry it's had to be such a rush. I think some of these depots could have been taken earlier, but I don't want to get into that at all. You'll all start blaming each other. I know how you all are. So let's not get into that. For impeachment purposes, again, this is this is really like the question Mr. Osias or the issue Mr. Osias and I just discussed. You'll have a transcript, which presumably will be a couple hundred pages, and you'll probably want to ask questions about 2 or 3 pages. Isn't it true, Mr. Witness, that you testified so-and-so? And then he'll look at the transcript and say yes or no and blah, blah, blah. But I had originally thought we could just get excerpts of the depot transcripts into evidence, but frankly, it may be simpler to just have the whole depot transcript be an exhibit for our record, and then the cross-ex can ask us to pull up the pages that we want. What do you all think about that? Any comments?
I think that would be fine. The question I would have is video. I know we do have sort of video of clips that we may have queued up if a witness sort of goes a different direction. How would we handle those?
Okay, now, and that gets to be more complicated, partly because those video files tend to be really big, and it takes a while for us to upload them and to screen share them. So I'm going to say this, and Ms. Meisenheimer, you tell me if you think I'm wrong. since you do have court reporters with written transcripts for the depots, which are that's the old way we did it. That's fairly easy for cross-ex. We don't have a jury or anything here. I'm not sure the demeanor of the witnesses is that critical, how the witness looks when he or she is answering a question. But is there really going to be a need for the video depot recordings to be offered into evidence, or will the written transcripts really be sufficient here?
It's a good question. I think it is a little hard for us to look at in the abstract, as some of the depositions haven't occurred and we actually don't have the videos yet. What I might suggest, I hear the logistical challenge, is that we confer with our tech people. And if there are, we would have it in the format of very short clips, 5-10 lines. And whether there's a way that we could be enabled to just share those clips from our end so we don't have sort of a complicated rigmarole getting it to you. I think it might be worth just having us have the ability to actually see these videos and figure out if there's a more efficient way of doing it.
Okay. If you have tech people who can do that, then that, and you think it really matters. I can read a written transcript, and of course the words are what primarily matters. But if you all, it's not just you, I'm not singling you out, but if anybody thinks, well, I really want to get this excerpt from the video recording to make my point beyond what the transcript shows, then if you can have tech people who can make a new file with just the part of the video that you think you want to offer into evidence, and you can cross-reference the written depot transcript so we know where it came from, so we have a context for it, then that can become a new exhibit that will potentially can be used for impeachment.
Yeah.
Okay, but please try to keep those short. Number one, so we can process them. And number two, because we're all going to have to watch it during the hearing. So we want to have those be short. Right now, I can't see that you're really going to need that, but I will leave that option open if any of you think, I've really got to show that. I really want to show how the witness was pulling his hair out while he was answering that question, or while his attorney was whispering in his ear while he was answering the question, or whatever. That maybe you'll need to do that. I don't think so, but if you do, I'll give you that option.
Thank you.
Okay. Anything else on that or on depot transcripts and recordings in general?
Mr. Moore, your mic is muted.
Oh, yeah, Mr. Moore, go ahead, unmute and go ahead. We saw your real hand. Something happened.
I'm going to leave
there
it
you go.
off for now. Yeah, thanks. In terms of taking on a deposition, you've got maybe 3 or 4 lines you want to put up and you want to cross-examine somebody on. But then you give up the entire deposition transcript. I think in most circumstances, you wouldn't put that in, because then you have to make a decision whether you're also putting things in earlier in the deposition or later in the deposition that you don't want in. You want one thing in, and if the other attorney sees other things he wants to put in, of course, he's free to do that. He or she is free to do that. But in the beginning, I think it's what the attorney wants in and not the entire transcript.
I was thinking about that question while we were talking. I didn't know whether any of you were going to bring it up, but if it's a representative of a party who's giving the deposition, there's no hearsay issue. I was going to say that's an admission, but it's former testimony. I'm pretty sure it comes in under that exception to the hearsay rule, and we don't follow the rules of hearsay anyway. So technically, the whole transcript is admissible, and I think anybody can offer it at that point. But the question is, what should we accept into evidence? And I don't think I want to have a whole bunch of deposition transcripts. I'm not planning to read them all unless somebody cites a certain passage in a deposition transcript and says, hey, this is really relevant, in their closing brief, and says, hey, this is really relevant to my argument. But if they want to do that, Mr. Moore, don't they have a right to do that anyway? It's at that, well, I don't know. Do they have a right to do that anyway, whether it's been brought up during the hearing or not?
Well, not if it hasn't been brought up in the hearing. If it was brought up in the hearing and you're requested to introduce it into evidence, then I think you have to introduce it into evidence. But then the attorneys for the other side are making that decision, whether they want some of this stuff in or they don't want it in. We have, in first, if we're the person trying to get the 3 lines, we make the decision whether we want those 3 lines or something else in. Otherwise, we can go back and forth and back and forth. But if there's something that would impeach the question that we have asked, of course, they can get that in too.
Right.
But I think the idea of I'm sorry.
Oh, go ahead.
Having a whole transcript in with 3 lines being outlined and nothing else, and maybe 150, 200 page deposition, I think that's really cumbersome. And I think that makes it more difficult for the lawyers to decide how they're going to handle impeachment evidence.
So I'm trying to think. I'm going to ask for other parties for comments on this. I'm not sure how to deal with this. I'm trying to think back to my trial experience. As I recall, when I used a deposition transcript to impeach somebody, I read the part and had the witness read the part, and that was it. And the whole transcript normally did not come into evidence.
Right.
Which we should probably, if my recollection of the trial court rule is right, we should probably follow that here. But does anyone else have any comments on this? I'm not sure how to proceed. Go ahead. Anybody else raise your hand?
Mr. Moore's comments actually bring up another issue. If the whole deposition transcript is going in, then parties have to make the decision whether they're going to respond to comments that are in the deposition transcript, whether the other side brings it up or not.
Right.
And that's a whole other issue. Sometimes we do the deposition just to see what we think the person's going to say. And maybe we'll ask someone else a different question actually at trial.
Yeah. It can open up a whole can of worms, so to speak.
I tend to agree with Mr. Moore on what gets into evidence. As for how it gets in, whether people just read it or submit excerpts or put the whole thing into the share site for the board, but only the parts that are read at the hearing are considered, I think all of those are valid options.
Okay, I think I've got a way forward. Does anyone else want to say anything about this? Okay, Ms. Mozine, your hand is up. Go ahead.
Yes, Mr. Lilly, thank you. Just an observation that indeed, as you've said, this proceeding is more in the nature of an administrative proceeding. And so often you will have items as part of an administrative record that will not necessarily come in full, if at all, into what is actually considered as evidence in the decision making. And I think that's what we're grappling with here. It may be that indeed the transcripts would be considered part of the agency's administrative record, but as far as what the administrative hearing officer is using to craft a recommended decision for the board, I would imagine we're probably in agreement that the evidence portion of that transcript would only consist of certain excerpts that are brought to the office's attention.
Right. I think that's what this may be a rare case where you're all agreeing, but I also agree. So that's good. It's good when you agree on things, even if it's just process. But so let's do this. The whole deposition transcript we'll put into the administrative record just so we have it to use. And again, I'm going to ask that it be given an exhibit number, name and number. The party that's offering it and wants to use it for impeachment, it'll be that party's exhibit and their next number. But then when we get to admitting exhibits into evidence, the offer by the cross-examining attorney will be, I'm offering exhibit, I'm just throwing out these numbers. Calliam 157 is the deposition transcript. I'm offering page 7 at line 15 through page 8 at line 12, which was covered during cross-examination. And that would be what's offered into evidence. And if it's accepted into evidence, then our proposed report of referee can cite that. But we would not cite any of the rest of the transcript, and people would not be allowed to cite any of the rest of the transcript in their closing briefs or other arguments. I think that's what you were all saying. Is that correct?
I think so, yes.
Okay, and I think that's probably
correct.
the way things are done in trials normally.
Yeah.
So let's do that. Yeah, I mean, I get it. The whole deposition transcript, I mean, there are going to be objections, and this and that, and a lot of peripheral things. And we certainly don't want to have to go through and rule on all that. That would take months or at least days. So we won't do that. So anyway, I think that's a good path forward on that. I will try to include something on this in my ruling so you all know what I've said. Hopefully I can get it down the way you've all agreed. Okay, good. We're making good progress. We're almost done. I will circle back to the Ian Crook's deposition. That's a separate issue, but I want to cover now site visit. My plan, assuming we are done with the hearing by then, is to start the site visit on November 4th at 9 a.m. Obviously, that means people who don't live in the Marina area will need to drive down. Well, you can do whatever you want, but we're going to drive down the night before and be ready to go at 9 a.m. And that way we can finish and go home to wherever we're going, and it won't encroach into the weekend. So I plan to have Mr. Wooldridge and Ms. Graziano go with me. I will ask one of them to take some photos and the other to take some videos, which I will put into the record. We'll try to keep them fairly short. And as far as whoever the tour guide is, at any point, I will ask him or her to basically say, this is what we're seeing. This is this, and this. And that's it. We're certainly not going to get into cross-examination about what do you think the extent of seawater intrusion is at this point under the ground or anything like that. I mean, that just doesn't work very well to do out in the field, because we have a recording, but it's not a good recording, and we don't have a formal setting for that anyway. So that's my plan. The video will just have the witness or the person describe what what we are seeing and what it is. So Mr. Neudecker, go ahead.
Yes, thanks, Mr. Lilly. Unfortunately, I have a wrench to throw in the works here. My operating assumption this whole time had been that the site visit would be limited to the portion of the CEMEX property over which Caliam has an easement, and that CEMEX's involvement would be little to none in the site visit. I see in the joint statement that the city and MCWD submitted, their proposal for the site visit has a reference to the CEMEX site, including monitoring wells 1, 3, and 4, test land well, and proposed well locations. So my operating assumption has shifted somewhat, and I think now the assumption, or at least the recommendation from the city and MCWD, is that the site visit include a broader tour of the overall CEMEX property, which I get and actually makes sense. And I think it probably does add value to see the entirety of the property, which is huge. Unfortunately, the CEMEX individual who is most appropriate to conduct that tour is not available November 4th. That individual is available the week of November 14th, with the exception of November 15th. This all came up just recently, so I haven't had a chance to confer with everybody about this yet, but I do understand that Caliam and its folks can make that week work. So again, I apologize for, requesting a move of the tentative November 4th date, but I think I have to at this point. I mean, and unless someone wants to educate me about what the site inspection is going to entail.
When in doubt, we go look. And you weren't arguing with that. Is this tour guide available earlier that week?
Might be. I didn't ask. I asked for no. I haven't asked that. I asked November 4th because that's the date that's listed as the tentative date in the order.
Okay, I'd like to do it on November 1, 2, or 3, even if it means we if we haven't finished the hearing, we can come back and do the hearing because we've reserved all those days on everyone's calendar.
Yeah.
So that's my first choice. What days did you say? Is it a he? I don't want to be sexist.
It's a he. It's a he.
When is he available? The following 2 weeks?
He's available the entirety of the week of November. He's not available the following week, but he's available the week of November 14th, every day that week except for the 15th.
So 14, 15, 14, 16, 17, and 18?
Correct.
Okay. So can you please talk with him and find out if he's available on November 1, 2, or 3?
Yes.
And if so, I think I'll just plan to schedule the site visit for then. Well, maybe I should ask, does anyone have any problems with November 4th? I'm not available on the 18th. And I don't think I'm available on the 14th. It would have to be 15 or 17 for me. Excuse me, 16 or 17. Does anybody have any problems on November 16 or 17? And you don't all have to come anyway. This I mean, you're all in. This is something else I think we have to cover. You're all invited, but I want at least one attorney per party. But you're not going to be missing a lot, and we'll have a video recording and photos of what's there. So I'm not hearing any stringent objections.
Your Honor.
Marina Coast.
Yeah.
It's not just the attorneys, it's the client, and I imagine CalAm's going to have the same issue. It seems that the coastal development permit application of CalAm at the Coastal Commission is very likely to be heard on November 17th, as far as we can tell. So that would likely be a difficulty for the parties themselves.
Yeah, well, obviously we don't want to conflict with that. I think somebody may have mentioned that before. So, okay, with the 16th, I mean, I understand you want to gear up for the Coastal Commission hearing, but if we had to, would the 16th work?
I'm
For
going
at
to
least
guess
some people. Go ahead, Mr. Wilkins.
Mr. Wilkins. I'm going to guess that'd be a very difficult day with the hearing before. I would suggest the day after if that's a possibility, because I am confident that my client and most of at least a couple of us on this phone, if the hearing happens, will not be available that day.
Because you'll be preparing for the Coastal Commission, you mean?
Well, not just preparing. We have to get all
Traveling.
our people together. There's a lot to do.
Yeah, no, I've been there. Unfortunately, the 18th doesn't work for me. So,
What about the hearing dates in December? We also have some availability there.
okay, that's a backup. I hate to encroach into that because we may need those days. I don't know how long that rebuttal testimony is going to be, but that will be our backup. So let's find out, Mr. Newdecker, if you can check with your tour guide, and we certainly want the most knowledgeable person so he can show us tell us about what we're seeing, and make sure we don't drive the wrong places.
If you heard typing about 10 seconds ago, that was me asking. So
okay.
Hopefully I'll get an answer sooner rather than later.
Okay, so we'll target November 1, 2, or 3. And then if that doesn't work, we will use one of the December dates. We are set for December 7 through 9 and 12 through 16, with the understanding that Ms. Meisenheimer was not available on 7 through 9. But for the site visit, I assume you'd let Mr. Spalding cover that if you had to.
Yeah, sure.
He probably could handle that one.
And I do appreciate everybody's flexibility on this. I appreciate it.
Well, yeah, and so that's important. Otherwise, there were some differences regarding exactly what we would go see, which I'm planning to firm this up after we've had some hearing days, because I'll know a lot more what I'm talking about then. But did anybody have any objections to, I'll just say, did either party or group of parties have any objections to the other party's proposal for the site visit?
Your Honor, Cal-Am did not think limiting the wells to just 3, or perhaps my memory's bad, 4, rather than all of the district wells that are used, what was appropriate. You should see where they all are.
Yeah, I'll just say right off, I agree with that. You all may say, what do you see when you look at a wellhead anyway? But if I'm going to go all the way down there, I'd rather get the lay of the land and see everything that may possibly be relevant. I don't think this is going to take more than a few hours. I assume we could drive. Are there any issues to any of these places?
Actually, Mr. Lilly, that did figure into some of the thought on our side in suggesting only several wells. If you want to see them all, I think our client is happy to show them to you. We'll have to check on accessibility perhaps of a couple of them. I think there is at least a dirt road, if not a paved road in each instance.
Okay, well, if we need, please let us know ahead of time, Ms. Mosine. If you can shoot me an email, and again, just CC everybody on the service list. The reason it matters for me is for the state, we can get a truck or some 4-wheel drive thing if we need to. I wouldn't do it unless I need to, because it's just, it's more expense and all that. Otherwise, I just get a regular passenger vehicle. But if we have to, we can. We can certainly get a ride with somebody else, but then everybody gets nervous if we're in a car with somebody else that we're talking to people and not other people can't hear and all that. So let me know if there's going to be an issue. And of course,
and my understanding, and we'll alert you if the actuality turns out to be different, but my understanding is as long as the driver is not, for example, a low slung sports car, it shouldn't be a problem. And a passenger vehicle with reasonably high clearance should be fine in most instances, I understand.
Okay. And if it all rains between now and then, I'll be very happy, but we'll deal with the logistics of driving on dirt roads. But we're never going to complain about rain in this business. So okay, well, I'll work with my staff on a proposed itinerary. Again, I just think, I'm not saying anybody had any ulterior motives or not, but if we're down there, my feeling is let's see whatever anybody thinks is relevant. I have no idea how useful this will be. With surface water facilities, site visits are very useful to me. With groundwater, obviously, you can't see as much, but I just thought it's a 3-hour drive for us to get down there. And usually it's useful for me to sort of see the lay of the land. So the assignments are Mr. Newdecker is going to tell us if the CEMEX guide is available on November 1, 2, or 3. Mr. Mosine is going to tell us if there are any issues with regular passenger vehicles driving on dirt roads to some of the MCWD wellheads. Okay. And if you can just try to get those to me, just email to the AHO admin hearing office email address with CCs to the service list, and we'll go from there on that.
Mr. Lilly, I know you still have the depot issue. I'm going to need to drop off at 11. I didn't want you to think.
Okay. Well, I assume Mr. Moore can continue to.
Yeah,
and
that's
Mr.
right up his wheelhouse. I did want to also softly suggest that if at the end or sometime during the hearings we're making progress sort of along the lines in terms of timing that everyone earlier in this CMC suggested could occur, which is a faster pace than we'll need all 7 days. If it's possible, rather than finishing sooner and sacrificing the last hearing days, if our first choice could be to give up Friday, the 28th, that is our once a year law firm in-person partnership meeting and get together with all colleagues. And if we're going to end up not needing all the days, which is going to be a prediction at that point, we would prefer, to use the November days and October 31 and give up the Friday day. So Mr. Moore and I and Mr. Betts could go to our partners meeting and get together. If that's not possible, we will obviously be at the hearing, but just so that's in people's minds as perhaps a first choice if we're running faster than the 7 days that are currently scheduled.
I'll make some snide comment about your partners are probably used to some of their partners needing to go to court from time to time, but I won't.
They're very used to it. It's not snide, and I'm not asking you, except if we're going to end up going faster than we thought. I mean,
Yeah.
somebody said, I can't see it going more than 3 or 4 days. We have
Well-
7 set aside. So if it looks like that at the end of or middle of Thursday when we break, people could acknowledge that Friday would be a dark. That's all.
Okay, why don't you go ahead and remember to raise that issue on Thursday around noonish, early afternoon.
Okay.
I mean, I don't want to be harsh here, and I understand the importance of your firm's partnership meeting. But on the other hand, my experience is no matter how much prodding I do on cross-examination, these hearings have a way of taking longer than expected rather than less than expected. So I'm very hesitant to give up a day unless I'm really, really sure we're going to finish by the end of the following week minus the site visit day anyway. Because the last thing I want is to give up a day and then find we don't finish in our allotted days. And especially with this group, I've found it's very, very hard to schedule additional days because you all have so many other conflicts on your calendars. So anyway, you can raise it, Mr. Asias, and we'll see where we are. If I can accommodate you, I will. But I'll just say, don't count on it right now.
Understood. I just didn't want to surprise everybody who might assume if we finished earlier, we'd be cutting off from the end. But
Yeah, and I'm sure everyone will be happy to have I'll say a day off from the hearing because then they can spend more time preparing for the following week. On the site visit, there were some questions regarding who may attend. I think, I'm not sure, but I think somebody said we limit it to one attorney per party or something like that. I'm not sure, I may be mistaken, but I don't, sometimes I have to limit site visits just because of logistics. We have to crowd into a narrow area or something like that. But I don't see that here. I think this is all sort of driving and getting out of cars where there's plenty of space. So, I don't think I need to have any limitations. You certainly don't all need to attend. I know, I suspect you all have fairly high hourly rates and your clients may not want to pay for you all to attend. So as I say, I would like at least one attorney per party. If you want to have more, that's up to you. We will have a video, which will turn on and off at each stop, and some photos so people who don't attend can do that. As far as other people, a reasonable number of client reps, if they want to come along and see, I mean, they probably all know the area a lot better than I do, but if they want to come, that's fine. I mean, technically it's a public proceeding, so I don't know that I really have a right to limit people anyway. So are there any other logistical issues with the site visit that we need to address? Okay, thanks. Okay, 2 other things, very important, and we'll be done. Thank you very much for bearing with me. I'm going to just keep going. We don't have a court reporter, so we don't need to take a morning break for that reason. There was an issue of requests to respond to new points made in other parties' rebuttal testimony. This would basically be, does anybody need to or want to have the right to file SIR rebuttal? So here is my plan. I wanted to let you know about it. At this point, I'm not going to provide for SIR rebuttal. I mean, I think we're going to have everything pretty well covered with direct and rebuttal, particularly when you've all had the right to submit things in advance. But if after the December hearing dates, if anybody thinks that there's something on SIR rebuttal that they really, really, really need to get into evidence, I will give an opportunity for parties to file written proposals, sort of in the nature of an offer of proof for additional testimony and exhibits that really is limited to responding to points that the other party made in rebuttal. And we will consider holding a hearing in January or February for that. The other thing is, which I'm almost sure I will want to have a hearing sometime in January or February, is after my staff and I have gone through all of this and have processed it and figured out where we are, we may have additional questions for the witnesses. And we'll try to ask what we can at the end of cross-ex in each round, but we may process this stuff and say, we really got the following questions and we want to be able to ask the witnesses those questions. And of course, I want to be able to do that so we can get to the bottom line. So I would like to schedule some dates. I just know how hard it is on people's calendars. But I would like to schedule some dates, probably not the first week of January, but sometime in January or February, just to hold them on people's calendars, at least for the purpose of my questions to the witnesses, my follow-up questions to the witnesses, and potentially for rebuttal. So let me just ask now, are there any, I almost hate to do this, but I have to. What dates are people not available during January and February for potential additional hearing days? And I'm gonna just go down, well, I'll just ask. Raise your hand if there are any days in January and February that you're not available. We'll start with you, Ms. Meisenheimer.
I'm in depositions the full week of January 2nd.
Okay, so not January 2 through 6.
Yeah, apologies, I'm just clicking through here. I also am out of town February 12 through 26.
12 through 26. Okay, I think that's around President's Day, which is likely to be a holiday for other people too. Okay, anybody else want to raise their hand and tell me when they're not available? Mr. Moore.
Yes, I have a trial starting on January 9th. Jury trial that probably goes through the week of the 9th and at least partially the week of the 16th, maybe the entire week of the 16th.
Okay, I'm going to give you the benefit of the doubt for that. So I'll put not January 9 through 20.
Right, thank you.
Okay. Anybody else? Oh, Mr. Wilkins, sorry, I didn't see you down there. You're in my lower left corner. Go ahead.
No problem. I think I heard you say for witnesses, and I'm okay. I can move things around that are on my calendar at this point, but I am concerned. I don't know that all of our witnesses are available on any particular days in January at this point. And
okay, and we'll have to play that by ear. Okay. So you don't have any specific dates. You're just raising a red flag.
Right.
Okay. Mr. Brochard.
I'm not available on January 30th.
Not January 30th. Okay. And Mr. Donlin, go ahead.
The first 2 weeks of February, Mr. Lilly.
Not
Available.
February. So what the February 1st is on a Wednesday. So what
specific? Yeah, February 2nd, specifically February 2nd through 14.
Not February 2 through 14. Okay. I think there's still, they're getting to be fewer and fewer dates. Ms. Mazine.
Just one last item. The morning of February 21st, I believe we have a status conference scheduled with Judge Wills in Superior Court in this case.
In this case?
I believe so. Others can correct me if I'm out of date.
He's going to ask what's going on with the State Water Board. Okay. And somewhere in this, anybody else? Oh, Mr. Spalding, did you have something?
Yeah, I am out at the end of February 23rd through early March.
What's early? Give me a date in early March.
March 7th.
Okay. I'm going to have to look at the calendar. I think there still were some. This is why I wanted to do this. I want to block out some dates. It looks like we may have some time in late January that'll work. And maybe this, shoot, between Mr. Donlin and Miss Meisenheimer, you've killed February, I think. So I'll see if I can get some dates in January and reserve them for this. And I will also be asking for closing briefs, and I'm not sure that, I think we can go ahead and get that process started, but I did want to block out those days. Do I dare ask? I'm afraid to ask, but I will. Does anybody want to tell me when they're not available in March? Just in case I need more days. And, I mean, at some point we may have to go forward without all of you being involved. I mean, each party has several attorneys, so I'm not sure we need to all be there, but do we hear any days in March? No. Not. Good, no hands up.
Well, actually, I had given.
Oh, yeah, Mr. Spalding. I had March through March 7th for you. Anything else?
Right, through March 7th.
Yeah, okay, I did have that. Thank you. And I'm not hearing anything else. So, I mean, I know you have busy calendars. That's why I wanted to reserve time ahead of time. Okay, so I'll look at that and see if we can block out some days when you're all available. The last matter I have on my agenda for today is Ian Crook's deposition. I read the arguments. As I understand it, basically Cal-Am argues Marina Coast and City of Marina already took Mr. Crooks's deposition in the underlying court case, and that therefore they should not have to produce him again to test for another depot. And basically Marina Coast and City of Marina should have waited because they knew he was going to be submitting written testimony and could have waited to take his deposition. And Marina Coast and City of Marina say, well, now we have his written proposed testimony. So we want to take his deposition at least to cover that. Is that a quick summary of the arguments regarding Mr. Crooks's deposition?
Slight correction, Mr. Lilly. Mr. Crooks was produced as a person most knowledgeable for Cal-Am before this referral had actually happened. So his personal deposition has never been taken.
Okay.
And I would add, Mr. Lilly, that the topics that he was deposed on were 7 topics that are completely different from the topics in his direct testimony.
Okay, does anybody from Cal-Am, well, wait, while we're on brochure, Mr. Brochure, Mr. Spalding, let me just write this down. How many hours do you think it would take to do a depot of Mr. Crooks just related to his written proposed testimony? I don't think he submitted rebuttal. I think so. Of his written proposed testimony for this hearing.
I would estimate a maximum of 3 hours.
Okay, Mr. Brochard, anything you want to add on that?
I think that's probably reasonable.
Okay. So does anybody from Cal-Am want to respond to either the written arguments or these oral arguments we've heard today about Mr. Crooks's depot?
Yeah, Bob Moore speaking for Cal-Am. Number one, one of your rulings said that the parties, if they have a dispute over deposition, go back to the Superior Court.
Right.
Obviously, you're not the Superior Court. There's an order saying that what they're doing right now is not proper under your jurisdiction. And any decision made, whether it was a PMQ or P, is up for the court to decide. And I think you can't do that without looking at the transcript and what was asked and the rest of it. So I think it's in the wrong place. And I think he has a right, stand on the fact that there's a 1 deposition rule. He doesn't have to come back again.
Okay. All right. So here is my conclusion and ruling on this. First of all, I agree with Mr. Moore. I did say before that I don't think I have the authority to compel Cal-Am to produce Mr. Crooks for deposition. The court has not delegated that authority to me. So far, discovery motions and orders related to them are still within the court's jurisdiction. However, I do think I have the authority to decide whether or not Mr. Crooks may testify in a hearing before me. And I think that's the nuance I hadn't raised before. This is not a ruling on a motion to compel. I'm not really talking about sanctions or protective orders or any of those types of discovery orders the courts issue. The court has the authority to issue those orders and I don't. But I do have the authority to control my hearing. So my ruling is that, and also I do tend to agree with, it was either Mr. Brochard, I think, said that if Mr. Crooks was previously produced as a person most knowledgeable, I don't think that's really the same as producing him in response to an individual subpoena. I know in my experience, a witness can end up having to testify twice, once as a PMK and then once individually. But particularly here, where the prior depo could not cover his written proposed testimony because it had not been submitted yet. I think, and I don't think it needs to be a long depo. I hope it doesn't. I mean, he had 5 slides and 7 pages of written proposed testimony. That's not a lot. So my ruling is that Mr. Crooks may not testify in the hearing before my office in this proceeding unless CalAm makes him available for a deposition before the hearing. And that deposition only needs to cover the matters that he discusses in his written proposed testimony and his slides. I'm not going to put a time limit on that. I'm a little hesitant to do that. That's perhaps extending beyond my authority. And also, I don't really want you all getting into an argument about that. But I think my ruling is he may not testify unless he's been made available for a deposition that covers his written proposed testimony and his slides. And I will leave it to you to figure out how to do that before the hearing starts next Wednesday. But I do think, in fairness to all parties, you all have had the opportunity to take depositions of all the other witnesses who are going to testify. And I think that right should extend to Mr. Crooks. So that's my ruling on that. Anything else to be covered today? All right, I will try to get out an order as soon as I can. I hope you've all been taking notes, so you now know what my rulings are, but I will try to get out a written ruling in the next day or two, just confirming all of this of who's doing what. But otherwise, we'll plan to start next Wednesday at 9 o'clock with the CalAm witnesses. And I'll ask CalAm's attorney during opening statement to tell us what the order is that CalAm wants to present those witnesses.
We will. Thank you.
So, thank you. Mr. Wilkins, your hand is up. Go ahead.
Just a quick logistical question. I believe it would be safe, and I want to make sure to tell Marina Coast witnesses that they will not be testifying in those first couple days, and that they won't be needed till the following week. We have schedules they're asking about, and I just wanted to see if you had any guidance to give us on that issue.
That is fine. You can tell them they will not need to testify before October 31st. Because if for some reason we finish CalAm's witnesses in 2 days, which would be good, I'm not too optimistic, but if we can, then CalAm has already asked that we don't have the hearing date on the 28th. So there's no way we're going to get to Marina Coast witnesses on the 27th. And if we did, we'll just break earlier. That's very unlikely. So yes, you may tell them they will not need to be available until October 31st at the earliest.
Thank you.
Yeah, that's a fair question. Anything else for logistics? We'll try to sort of plan ahead each day as to what witnesses are going to testify the following day. I know that usually helps us all, and we don't have to go all the way until 5 o'clock. If we finish up a panel of witnesses at 4, I'm not going to start a new panel after that, the same day, we'd wait till the next day. So anything else for today? Okay, well, thank you all very much. I appreciate all your hard work and your filings with me and in preparing for the hearing. And I'll look forward to seeing you all next Wednesday. Thank you and goodbye.
Thank you, Mr.
Thank you.
Lilly.
Thank you.
Thank you.